This is one of my concerns because when I look at this is not about Trump. I think depriving someone of their liberty in the United States of America comes at a very high standard and well should. And I don't know what liberties they're going to deprive Trump of. I mean, they could deprive him of his liberty to vote, to own firearms. They could put him in jail. They could deprive him of his liberty to travel freely. I don't know what liberties could be impacted by this, but to deprive someone of their liberty in America comes at a very high standard. It's not a preponderance of the evidence, which is the lowest standard that a jury looks at. A preponderance of the evidence is when it can be 51-49. It's more likely than not. Yeah, we find for this side. Clear and convincing evidence it's just what it says, clear and convincing. It looks pretty likely that's what happened. But beyond a reasonable doubt, I've worked with juries most of my professional career, and I've always interpreted that to mean that you send 6 or 12 people into a room and they debate, talk about this, and they conclude that there's no issue here about which reasonable people could disagree. These things are clear. There's just nothing here about which reasonable folks could disagree. And that's a pretty high standard. It seems to me that there are some things that lead up to that you're entitled to face your accusers, you're entitled to know what you're charged with, and then you have this standard where people have to reach beyond a reasonable doubt in their findings, and it has to be unanimous. They've just run all over these standards in this case. And if they can do that to a former president of the United States, and that's allowed to stand, what happens to the average citizen? What happens to somebody that gets hauled into tax court, for example? If these standards all of a sudden just get thrown to the side and they don't get due process. Isn't this jeopardizing all of us?
You started by saying this is not about Trump. I would amend that slightly. It is about Trump because the case wouldn't have been brought if Trump were not the guy.
Good point. It's not just about Trump.
It is about much more than Trump.
Right.
And what has happened to Trump, if it can happen to him, it can happen to anybody. And when Trump has said, as he frequently says on the campaign trail, if they're coming after me and you're next, I'm stopping them. I'm standing in the way, and I'm going to stand up to them. He needs to do that, and he needs to say that. But you're right. What has happened to Trump is all of the things you said, plus the evidence that was admitted and excluded in this case was erroneous. If it can happen to someone like Trump, it can happen to the least of us.
There are a lot of people listening to us right now and watching us right now. What should the message be? What should people take away from seeing what's happened here? You've been very clear that this case should never have been brought. I agree completely. And it doesn't matter whether you're a Democrat, Republican, pro-Trump, anti-Trump. It doesn't matter. What we're talking about here is this new term that's been coined, lawfare, that warfare has moved into the courtrooms. Lawsuits are being used as a weapon. So it doesn't matter if you like Trump, don't like Trump, Democrat, Republican. This is terrible. It smacks of banana republic tactics. What's the takeaway here? What should people take away from this?
I agree that the stench arising from this case is something you can't miss. And we have an imperfect but wonderful judicial system in this country. Our jury trial system works well. It doesn't always reach the right result, and it requires people who are involved in that system to be respectful of it. And when you have, as we saw in this case, a prosecutor and a judge who don't treat the case as the law requires, who are concerned most about winning and not about doing what's right and what the law requires, you send a message to the rest of us that we just can't trust lawyers or judges or the results of trials. And there's been a lot of talk about the loss of respect for the law, and much of the time people are saying Trump is the assailant, the one who is threatening the rule of law. It's the other way around. Trump is the victim of this assault on the rule of law, and that's what it was.
This should be reversed. We know that's not, they don't care about that, but this should be reversed.
It will be.
It'll be thrown out.
Yes.
And when it's thrown out, the options will be to just vacate it or to retry it?
It depends on the basis on which it is reversed. If it is reversed on the ground that A, the payment of hush money was not a crime, B, the cover-up was not a crime because you can't, if what you're covering up wasn't a crime, covering it up isn't a crime. C, there wasn't any election law violation, either state or federal. If it's thrown out on those grounds, it's over. It can't be retried. If it, however, it is reversed on evidence grounds, that you shouldn't have admitted this evidence, you should have admitted this other evidence, then there could be a second trial.
You think they'll be motivated to do that?
Well, I think it's going to get reversed and rendered on the law points that we mentioned.
So it won't be remanded, it'll be rendered.
I think so.
Yeah. So what will happen now? July 11th, Trump goes back for sentencing.
Like, what's that, like 2 days before he gets the nomination or something?
4 days before the GOP convention.
Nobody knows what this judge will do, and he's full of venom. But I cannot imagine that his sentence will be to put Trump in jail. And if he does sentence Trump to jail, I believe he will suspend the sentence pending appeal. And if he doesn't, I believe Trump will be able, in short order, to get the Court of Appeals in New York to suspend the sentence so that Trump will get the nomination and run. The practical issue is this felony conviction going to hurt him or help him? My own guess is I don't see how it helps. It certainly galvanizes the people that are going to vote for Trump anyway, makes them more determined to do so. But if I'm sitting on the fence and somebody says to me, well, aren't you going to vote for Trump now that he's a felon? I don't see many people jumping off the fence in Trump's direction.
If he puts him on probation, will they stay that?
You know, it depends on the terms of probation. Most of the time, maybe all the time, someone on probation has to report into the probation officer and can't leave the state or the city or some confinement like that without permission. I can't imagine that being done to somebody who's in the midst of a 50-state political campaign. So I think that too would be suspended.
Surely it will.
Please.
Surely it will. Is there anything I haven't asked you about this so far? There's some details we're going to go into on the show, but is there anything I haven't asked you about that you feel a need to say in this conversation?
The only other evidence point that we ought to talk about is the exclusion of the expert witness that Trump offered. Once the state was allowed to put in Cohen's guilty plea to a federal election law violation, Trump should have been entitled to bring on a witness who would say, what happened here is not an election law violation, and then talk about the difference between the campaign expenses, which you have to report, and personal expenses, which you do not have to report. And he should say, a campaign expense that has to be reported is something like paying for television ads or paying for office staff or rent. That has to be reported if you spend that money. But if you spend it to silence a hooker, that's a personal expense. And you don't have to report them. And here's some other personal expenses that Trump has every day. He dyes his hair. He gets under a sun lamp. He uses a lot of hairspray. Those are personal expenses, and they don't have to be reported, and neither does paying a hooker.
Well, they had Smith, former chairman of the Federal Election Commission, who was prepared to offer testimony that the things they were complaining about would not have been violations for a variety of reasons. One, that the business records occurred after the election and therefore could not be part of a conspiracy or violation of election law. That was part of his testimony, correct?
I doubt it. He was an expert on what's a campaign contribution and what's a personal expense. And that's a different legal question. It doesn't really have to do with the ins and outs of campaign finance law. The only thing it has to do with is that you don't have to report them until after the election. So had he reported them in a timely way, it would have been after the election. He could have said that.
He could have said that. But he did an investigation. Who did the investigation in 2016?
He was on the Federal Election Commission that declined to pursue Trump for violating the election laws, for doing exactly what Alvin Bragg, the district attorney, said Trump had done.
He declined to do the investigation?
He did the investigation. He declined to prosecute.
Okay. He found no violation?
I don't know if it was a formal finding. I think it was. I think they wrote an explanation for why they weren't going to pursue it.
But they did find no violation, no fine, civil or criminal, and he was going to testify to that.
Yes.
Which would have offset
Cohen's testimony about, I'm guilty, I violated the election laws by paying Stormy and not reporting it.
Why was that excluded? What was the reason given?
It is pretty well settled that you almost never, there are some cases that I have had experience with where an expert is allowed to testify about the law, but it's when the law is really arcane and not many people know it or understand it. Generally speaking, the jury gets its law from the judge. And generally speaking, you don't call an expert to come in and say, well, I know there's an election law violation alleged here, but there wasn't one, because he's usurping the duties of the judge. And that would have been a good reason to keep it out if the judge hadn't let Cohen's plea agreement in and let them question Cohen about pleading guilty and being guilty. But once that door was open, in my view, the judge should have let it in, let the expert testimony in.
Why wouldn't they have moved for a bill, sent the jury out, and put it in the record?
We don't know that they didn't, but they certainly should have sent the jury out, put that guy, Brad Smith, if that's his name, on the stand and asked him the questions that they wanted the jury to hear. And then having completed that, they should say to the judge, I want you to let me do this in front of the jury. Will you do it now that you've heard it? The judge would have said no, but by making that record, by asking those questions and getting those answers, they would have preserved this point for appeal. It may not have been preserved.
So if they didn't do that, they may have waived that?
Maybe. It depends on the colloquy that went on around it.
Depends on what they said back and forth?
Yes.
That would be too bad.
He's got enough. He's going to get this thing reversed.
Either way?
Yeah.
Even without
it?